Welcome, everyone. I'm Sunny Hostin, and I'm so excited to be moderating today's panel on HIV is not a crime. This year marks 40 years since the first reported case of HIV/AIDS. Since that first reporting, the scientific community has made dramatic advancements to prevent the spread of the disease and to allow people living with HIV the opportunity to live long and productive lives. What was once a death sentence is now a preventable and manageable disease. Despite this medical progress, more than 100 countries have either HIV-specific criminal laws or use other criminal laws to prosecute people living with HIV. Many of these laws prosecute acts that pose little to no risk of HIV transmission, such as biting, spitting, and breastfeeding. That's what brings us here today. For the last year, the Elizabeth Taylor AIDS Foundation, along with the Health Not Prisons Collective, and with support from Gilead Sciences, has been working to raise awareness about these criminal laws on a global scale and has successfully been fighting to modernize the laws across the United States. It's been such an honor to support them in this fight, and it's now my honor to bring it to the 11th Annual International AIDS Society Conference on HIV Science. For those who are not familiar, Elizabeth Taylor worked tirelessly throughout the 1980s and 90s when the AIDS crisis was fueled by fear and not facts. In 1991, she founded the Elizabeth Taylor AIDS Foundation to fulfill her desire to see an AIDS-free world. Like Elizabeth, our panelists today have dedicated their lives to social justice and ending HIV stigma. They represent some of the world's top experts on HIV decriminalization, and I'm honored to welcome them all to today's discussion. Edwin Bernard is the executive director of the HIV Justice Network, where he works to end HIV criminalization on a global scale. My friend Robert Suttle, who was incarcerated as a result of his HIV status and has since become an advocate for reform. Dena Williams is an HIV and transgender activist and has been working with the HIV Is Not a Crime campaign to modernize HIV criminal laws in more than 30 states across the United States. And last but not least, Sarai Chisala-Tempelhoff is a lawyer currently working in Malawi to decriminalize HIV. Edwin, let's start with you. I'm aware of HIV criminalization in the United States, but was surprised to learn that this is such a global issue. As a journalist and social justice activist, you have dedicated much of your career to bring light to injustice. In your current role with the HIV Justice Network, you have a lens on how the issue of HIV criminalization affects the rest of the world. I know you have prepared a presentation. Can you share more about the current global state of HIV criminalization?
Thanks, Sunny. So at the HIV Justice Network, we monitor laws and prosecutions all over the world, produce advocacy tools, and build the evidence base against the unjust criminalization of people living with HIV. We also coordinate the global movement against HIV criminalization known as HIV Justice Worldwide. So HIV criminalization laws single out people with HIV, which is inherently stigmatizing, making us solely liable for HIV prevention when we all know this is a shared responsibility, including a responsibility of governments to create a supportive and enabling environment. Many prosecutions allege HIV exposure even when this isn't possible, and others allege HIV transmission even when it can't be proven. And if someone's found guilty, this can lead to disproportionately harsh sentencing compared to similar risks or harms. So if you visit our global HIV criminalization database, you'll see there's no one typical law, although most HIV criminalization laws are overly broad, vague, and unscientific, including not reflecting up-to-date understanding of HIV science. International guidelines on HIV and human rights, as well as the Global Commission on HIV and the Law and the new UNAIDS Global AIDS Strategy, all strongly advocate against overly broad HIV criminalization. To punish those extremely unusual and rare cases of malicious intentional transmission, it's recommended to use general criminal laws, but only as a last resort. UNDP has just published guidance for prosecutors on HIV-related criminal cases to help limit the overly broad and unjust use of any kind of HIV criminalization law. And this includes all the recommendations contained in the expert consensus statement on the science of HIV in the context of the criminal law, which was launched at AIDS 2018. Whatever kind of law is used, most cases that we monitor involve an HIV-positive person having sex where it's alleged they didn't disclose their HIV status. Sometimes people are prosecuted even when they have disclosed, and even when their partner consented to the risk, although how do you prove you disclosed if a partner is retaliating by going to the police following a breakup? Many cases involve potential or perceived exposure only, with no HIV transmission alleged. Many involve negligible risk. For example, condoms were used, or the person had a low or undetectable viral load, or it was just oral sex, or they were just soliciting for sex. There's also far too many prosecutions for spitting or biting. And in the minority of cases where HIV transmission is alleged, the first person diagnosed in a couple is often considered to be the first person infected and therefore guilty, when that's not necessarily the case. Phylogenetic analysis, which could potentially exonerate people falsely accused of transmission, is rarely used, and even when it is, results can be misinterpreted. There's even been prosecutions for vertical transmission and more recently for breastfeeding. In short, HIV criminalization is a triumph of stigma and discrimination over rationality and science. So as you can see from this map of the world, HIV criminalization is a global phenomenon, and although it began in the US, it's now a problem in most regions of the world, notably in Eastern Europe and Central Asia, and across sub-Saharan Africa, as well as in North America and Western Europe. Our most recent analysis tells us that there are at least 50 active countries, another 60 countries of concern, those with current HIV-specific criminal laws on the books, and others with proposed new laws, and a further 20 that criminalized people with HIV in the past, haven't done so recently, but still could. And in 2020, when the world and law enforcement was preoccupied with COVID, we still documented at least 90 cases of unjust HIV criminalization in 25 countries, and women living with HIV were accused in a quarter of those cases. Typically, Russia and the United States are the worst offenders in terms of absolute numbers, and 2020 was no exception, and it's not looking any better for 2021. The US has around 30 states with HIV-specific criminal laws, and between them and the states that use other kinds of criminal laws like reckless endangerment, terrorism, attempted murder, we see that they're commonly enforced by police who are already targeting Black and brown people, who are often also sex workers, people of trans experience, migrants, or gay men. The good news is that although there's a long way to go, influential people in US policy have begun to see the light. The CDC's Jonathan Mermin recently wrote in The Lancet, "Truly ending the HIV epidemic will require community support, institutional and political trust, and shared goals. HIV criminalization laws and the misapplication of general statutes run counter to this effort. It's time to align with science and consider reforming, rescinding, and revising the application of these laws for the sake of people with HIV and for the public's health." So Virginia, Nevada, and Illinois recently became the 8th, 9th, and 10th US states since 2012 to modernize their HIV criminalization laws, and efforts are currently underway across the US, many of them supported by our HIV Justice Worldwide partners, the Zero Project and Positive Women's Network USA, as well as by the Elizabeth Taylor AIDS Foundation. At the start of the 21st century, no country on the African continent had HIV criminalization laws. However, inspired by the US, a slew of HIV-specific laws began to appear across the continent in the mid-2000s. And this so-called legislation contagion contained many useful provisions to support national HIV responses, but the laws also contained problematic HIV criminalization statutes that have been disproportionately applied to women living with HIV, despite the erroneous idea that such laws would protect women. And you'll hear later from Sarai why that is unfortunately not the case. But fortunately, thanks to increased awareness and some modest funding, although never enough, the global movement to end HIV criminalization has grown enormously in the past few years, and efforts are underway all over the world to educate policymakers, challenge existing laws, prevent new ones, and to defend and support people unjustly charged, convicted, and incarcerated. You can help too by learning more about HIV criminalization in your own jurisdiction and then joining the movement for HIV justice worldwide.
Thank you so much, Edwin. Dena, thank you for being involved with the HIV Is Not a Crime effort. You began your activism by doing HIV outreach in inner cities where the rates of infection are disproportionately high among people of color and LGBTQ plus youth. You have since remained very active in the LGBTQ plus community, most recently as the board chair and CEO of the groundbreaking Trans Chorus of Los Angeles. You know all too well that transgender women of color are disproportionately affected by both HIV and criminalization. How can we all advocate more strongly to help trans women who are criminalized for their HIV status?
Thanks, Sunny. The unfortunate truth is that trans women of color aren't only disproportionately affected by HIV criminal laws. Trans women, and particularly trans women of color, are deemed guilty by law enforcement simply by being transgendered. And the statistics show that police disproportionately target Black trans women. Unfortunately, one of the harshest realities many trans women and trans youth face is the experience of homelessness. This situation in life is brought on by a multitude of factors. Some experience rejection from their families, and many trans women find it almost impossible to find stable and suitable employment because of the discrimination that they experience on a daily basis. Because of this, many trans women are forced into sex work as a means of survival. This type of work puts trans women directly in the line of fire. So, what can you do to help trans women of color? Currently, there's a severe lack of HIV data in the transgender community. Researchers need to actively engage in the trans community in order for us to understand the HIV infection rates. Researchers need to ask the questions, how do HIV infection rates in Black trans women compare to those in other populations? How do homelessness and sex work affect the rates of infection? There's also a lot of fear and unwillingness to be tested for HIV in the trans community. It stems from fear of prosecution, either for HIV laws or for sex work laws. And then the prison system can be even more scarier for trans women, where they're processed as male instead of as female. We need researchers answering all of these questions. We also need Black trans people actively doing the research. So I urge you to work with diverse officers to make your school supportive of Black and trans student and mentees. Create scholarships, hire people of color, make sure your institutions have gender-neutral bathrooms, and allow name and gender changes on formal documentation. We need the leaders in the field of HIV research to listen and to lead. Science needs to be equitable. Thank you.
Thank you so much, Dena. Sarai, thank you for being here today. Sarai, you currently serve as the Executive Director of the Gender and Justice Unit in Malawi. Prior to this role, you worked as the Director of Gender and Women's Rights under Malawi's Human Rights Commission. With over 15 years of experience fighting for human rights as a lawyer and women's activist, you have a deep understanding of how HIV criminalization is particularly dangerous for women. In your current work, you are fighting for HIV criminal law reform and have been highly involved in helping women criminalized for breastfeeding while HIV positive. Can you please share more about this?
Thank you, Sunny. And yes, as you mentioned, in Malawi in 2016, a court sentenced a woman that we have known as EL, a woman living with HIV, to 9 months imprisonment after being found guilty of accidentally breastfeeding another woman's child. This case came to everybody's attention when it was brought on appeal. And during the appeal of her case, the court said that she could not have intended to transmit HIV and could not have known that there was a likely risk because, in line with the science, the evidence indicated in her case, it was likely that she would have believed that breastfeeding was safe, and in addition, that she would not intend to breastfeed the child, that it was an accident. It was an interesting case because the court really considered the expert evidence, which was talking about the risk of transmission for a woman who was on ART as EL was, following a single exposure through breastfeeding. The court and the evidence understood that it was infinitesimal. Malawi's breastfeeding guidelines also promote breastfeeding as being safe for women on ART. Because the accused was breastfeeding her own child, the woman EL, the court also considered that there was no way that she could have intended to transmit HIV to the complainant's child, and not to mention that the conduct itself, the act of breastfeeding, was not intentional. So she never meant to breastfeed this child that didn't belong to her. The elements of the crime that require intentional or reckless conduct and likelihood of transmission therefore could not have been satisfied, despite this being what was being claimed and what was on the law books at the time. And so she was acquitted. The court did emphasize that bias against the accused was illustrated by the conversation that was held in the magistrate's court. This was the court that originally convicted her, found her guilty and convicted her. And therefore, in upholding their appeal, they included a careful consideration of the science. And that makes this case a very special one, not only for its time, but for advocacy that came after that, because EL was convicted on existing legislation. And at the time, Malawi had been considering a bill or a proposed law that would further criminalize and stigmatize people living with HIV and AIDS. The court made a number of statements on HIV criminalization more broadly, including that the function of the law should be to protect people from unjustified public panic, and that it is important to consider, if using the general law, HIV non-specific crimes like assault under the common law, which happens oftentimes, to prosecute HIV transmission cases, that fair trial rights should be upheld, amongst others. EL was released back to her community as she was acquitted, and so it was as if she had never committed a crime in the first place. And at that point, community support became a critical aspect of her reintegration into the community. It was a tight and small community, and many members of the community knew of her case. They knew of her incarceration. They knew of the accidental breastfeeding incident. And there was a great deal of confusion around everything that had been going on. Organizations such as the Coalition of Women Living with HIV and AIDS, known as COLA, and the International Community of Women Living with HIV and AIDS in Malawi, were supported to really work with community members in ensuring that EL's case was understood, that the subsequent appeal case was explained carefully, that the science of HIV was understood. These are things that we assume people understand because we've been living with HIV for so many, many years. The reality is that in many parts of the world, there's either been fatigue or there is still a lack of understanding of the more technical aspects, and especially when it comes to issues of risk of transmission or exposure. This case raised concerns about the severity of stigma and discrimination that continues to exist against people living with HIV, in EL's community in particular, and her social well-being following her return. COLA, the Coalition of Women Living with HIV, continued to provide psychosocial support and counseling to her and her family, as well as engaging the community and traditional leaders on issues concerning HIV treatment and testing, stigma, and discrimination. Community sensitization and a support group were established in the community. What we do know is that her case influenced not just the community, but those two organizations, COLA and ICW, to thinking about what HIV criminalization means on a bigger scale. And like I said previously, this was simultaneously with Malawian Parliament considering a proposed legislation that was HIV specific and would criminalize specifically breastfeeding and other forms of intentional and unintentional exposure, and included provisions that would screen domestic workers, police officers, immigration officers, and others for HIV when they approach institutions for recruitment. So this case galvanized a bigger movement in advocacy and coordination and collaboration on what the proposed criminal provisions would mean not just for people living with HIV, but women living with HIV in particular. EL's case had us all join forces, and influence advocacy, bringing together women who are living with HIV. And in doing this advocacy, we realized that conversations around an HIV bill that had existed on the books for over 10 years were elitist and were conversations that were taking place with people who already understood the issues at hand, scientists, lawyers, parliamentarians, and other stakeholders. So with EL's case and with the involvement of COLA and ICW and other partners, we decided to take a different approach altogether by centering women living with HIV and ensuring that they control the narrative about how their lives experiences and just what they expected to come from this HIV bill would mean for them in person. They spoke truth to power. In this instance, it was no longer a theoretical conversation. It was a conversation about their lived realities. And so when these new HIV-specific criminal laws were proposed, the EL case was directly cited in the legal submissions and the advocacy to resist criminalization in the law, and to illustrate how irrationally these proposed protections would be applied and the dangers that they pose for women in particular. I remember one woman really took my heart when she said, "Before you, as parliamentarians, care about the baby that I carry in my womb, I care about the well-being of my baby." And so proposed laws that are there allegedly to protect women from being infected with the HIV virus actually would be used to persecute women for breastfeeding, for applying for domestic work, for falling in love, just for living with HIV. EL's case saw a complete shift in the way we were discussing HIV criminalization in Malawi, and with people understanding it from the perspective of women like EL who are already vulnerable, are already marginalized. We saw that lawmakers agreed to remove the most problematic provisions from the bill. The law was passed without any criminalization whatsoever. And instead, the law that we have on our books now is a more protective one that focuses on the rights of people living with HIV, that focuses on access to medication and access to free medication, as a matter of fact, and focuses on non-discrimination, special clauses that we don't have anywhere else on our law books. Thank you so much, Sunny.
Thank you, Sarai. To introduce our next guest, I would like to show a brief video that best tells his story. Please take a look at the Elizabeth Taylor AIDS Foundation's True Not Crime story featuring Robert Suttle.
Let me tell you a story about a guy in Louisiana. It was New Year's Eve, 2007. He went out to meet friends at a local gay club, and he met someone who was interesting, attractive, intelligent. At the end of the night, the two went back to someone's place. Alone, he told the someone his truth. "I'm HIV positive." He wasn't sure what would happen next, but the two decided to see each other. One night turned into 3 months, but eventually their relationship soured, and it ended. He moved on with his life and his career, but little did he know that someone refused to do the same. He was working as the assistant clerk at the Louisiana Second Circuit Court of Appeal when officers showed up looking for him.
"Do you know this person?"
He responded yes, and with that, the officers left. Weeks later, he found a search warrant left on the kitchen counter. The officers came to look for anything related to his HIV. It went quiet for a few months until the officers returned to the courthouse.
"Please place your hands behind your back."
"What for?"
"Do you want me to say it?"
He remained silent as they stated the charge.
"Intentional exposure to the AIDS virus."
From there, he was arrested and placed into state custody until it was time to see a judge.
Case 271028, the State of Louisiana versus Suttle. 1 count of intentional exposure to AIDS virus. On September 9, 2008, the accused arrives, present with his attorney at law, and pleads not guilty to the charge.
In the end, he had to make a decision: face up to 10 years in prison or take a plea.
The accused withdraws his former plea of not guilty and pleads guilty to the charge of intentional exposure to the AIDS virus. The defendant has been sentenced to pay a fine of $300 and court costs.
When pleading guilty, he was unaware that it would be mandatory that he be listed on the sex offender registry for 15 years. He was also unaware, although his initial plea carried no jail time, this clause did carry mandatory jail time. And almost a year later,
The accused, present with new counsel, having previously pled guilty and been sentenced, now comes for resentencing. The court has set aside the previous sentence. The defendant is sentenced to pay a fine of $300 and court costs with credit for time served. The defendant is to be confined at hard labor for a period of 6 months and committed to the Louisiana Department of Corrections.
he got out January of 2011. As of today, he's still on the sex offender registry. Since being released, he has become an advocate for people living with HIV. He helps others so that they don't go through what he went through. He fights for a day where we not only end the epidemic, but also end the stigmatizing treatment of those living with HIV. He is me. I am Robert Suttle, and this is my HIV true story.
Robert, wow. I've watched that video a couple of times and it still takes my breath away. Thank you for being so vulnerable and for being such an incredible advocate for the HIV Is Not a Crime campaign. Your story so clearly outlines the injustices of HIV criminal laws and penalties. We also know that criminalization highly affects men having sex with men, particularly Black and brown men. How can we be effective advocates for men having sex with men?
Thank you, Sonny, for that question, and it's good to see you again. I think it's important that we start with acknowledging that it's been 40 years into the epidemic in the United States and around the world. I think it's important to understand the climate or the social climate in which gay men or men who have sex with men are in, and that gets them in situations regarding HIV criminalization. You know, it's 40 years since the first AIDS cases was reported in 1981 in LA and New York City. The southern region of the US is the epicenter of the HIV epidemic. And the reason why I'm focusing on this particular region is because it's the region where I come from, where my story originates out of. Southern states today account for an estimated 51% of new HIV cases annually. Think about that, 51%. Among MSM, the number of new diagnoses, 1 in 2 Black, African American, or 1 in 4 Hispanic, Latino, gay, bisexual, or same gender loving men may be diagnosed with HIV in their lifetime. The US is the world leader in incarceration. That is a 500% increase over the last 40 years. We're talking about 2 million people in jails or prisons here in the US. So the lifetime likelihood of imprisonment for US residents born in 2001 would, for Black men, it'd be 1 in 3, and for Latinx men, it'd be 1 in 6. So this is like a perfect storm for HIV criminalization, is understanding how people are incarcerated, what rate are they incarcerated, and also in what rate are our MSM contracting HIV. And the reason this is happening is because of the existing structural and institutional racism, cultural conservatism, and religious intolerance that infects all aspects of our society, particularly our criminal justice system and our public health system here in the US. So I want to run through just some of the experiences among MSM living HIV based on these facts that I've given you about diagnosis, as well as about people being prosecuted. So we're talking about politically vulnerable and social communities, populations. They already face multiple intersections of stigma and discrimination even before they contract HIV, simply based on who they are or how they identify as men loving other men. Historically, and even in present day, they're subjected to heightened surveillance and victimization by law enforcement. A study by the Williams Institute found that substantial evidence that LGBT individuals and communities continue to face profiling, discrimination, and harassment at the hands of law enforcement officers. Coming from socially and politically vulnerable communities, they are people living with and affected by HIV frequently. There's a lack which leads to a lack of dialogue among HIV negative and HIV positive gay and bisexual same gender loving men. Most Black men and Latino men are not likely to disclose their status if they feel that they're in an unsafe environment to disclose that, whether it be to family, to their friends, or even to their provider. Continuing with the experiences among MSM living in the US, there's a distrust in the health system due to breach of confidentiality or carceral public health strategies, which can exacerbate disparities for Blacks and Latinos. There's also legal vulnerabilities based on their HIV status. When a person is newly diagnosed, they're unaware of how to negotiate disclosure or behaviors that make them criminally liable. They're unaware of outdated felony laws. They may have unfair representation in court simply because they are a person living with HIV. It is assumed that they are a threat, that they are a danger to others. And by that, they may face lengthy prison sentences with having that conviction. And last but not least, if you live in a particular state, you may have to do sex offender registry. There are those requirements that require you to have your face put on notification cards in your community, or even in my state of Louisiana, where they have you put the word sex offender on your driver's license. So can you imagine that? So disfranchisement and collateral consequences are prohibiting people from accessing employment, housing, education, and other benefits of opportunities. And last but not least, the conviction becomes a life sentence. There are many challenges that still exist for people who have convictions even beyond them getting out of prison. So with the communities and the coalitions that I've been fortunate to work with over the past 10 years in my advocacy, we decided to have a racial justice focus because we recognize the importance of seeing the communities that are disparately impacted. It is important for those people to be centered and for those people to be leaders and to be part of the decision making about advocacies and about strategies that address changing or modernizing laws in the various states. So my first group is the Elizabeth Taylor AIDS Foundation, HIV Is Not a Crime Council of Justice Leaders, which is I am chair of this particular council. This is a network of criminalization survivors, people who've actually gone through or been threatened with prosecution, coming together, lending our voices, sharing about our experiences. That is what's important in regards to movement building and making people aware of that this actually does happen. So we need people that have gone through to really be able to tell their story. Here in the U.S., we also have the HIV Is Not a Crime Training Academy, which is a grassroots decriminalization movement where advocates, people living with HIV, policy people, attorneys, all kind of stakeholders come together and learn how to talk about HIV criminalization. What is the messaging that we're all saying across the country, and also finding strategies to be able to change laws there on the ground in various states. We also have the Health Not Prisons Collective, which is an intersectional initiative of national networks. We have the Counter Narrative Project, which does a lot of gay advocacy for Black gay men. Positive Women's Network, which speaks for itself, women living with HIV. The Suttle Project, which I was also a founding member of the organization. We have the Transgender Law Center, because we recognize the importance and the visibility of trans people and trans people living with HIV. And also we have the USPL HIV Caucus, which is a network of networks. We also have some other organizations that I've been fortunate to work with that do a lot of policy work on the federal level, which is the National HIV LGBT Criminal Justice Working Group. It consists of various organizations that are doing work not just only in HIV, but also in sex work, trans advocacy, Black gay men, all sorts of other works that intersect. And also the HIV Justice Network, which you've learned about through the executive director, Edwin Bernard, which monitors all that goes on around the world around HIV criminalization. And so it's very important that these communities are involved or are leading and making the decisions about how they see fit in terms of justice for them, for their communities.
Thank you so much, Robert. And thank you all for your participation, for sharing your personal stories, and for being a part of this important fight. And to all of you in the audience, thank you for giving us your time and attention. If you would like to learn more about this work and the role that the Elizabeth Taylor AIDS Foundation is taking to modernize HIV criminal laws, please visit etaf.org. With that, I'm sure many of you have questions, so I'm going to now pass this back over to Dena Williams for our live Q&A.